Mr. Copeland says, essentially now or when I got locked up, and he said that's I think he said that's what my baby mama told me. So it's clear his source of information is someone else who's telling him about this alleged internet argument, and he doesn't have any personal knowledge of it. And
all right, sir.
It adds absolutely nothing to the context of this statement, other than it brings in hearsay evidence about my client, which I object to.
All right.
You're on the section about Twitter. We won't play. We'll just pick back up when Detective Gator was trying to clarify, like an issue. When was he shooting that shoot? Just try to clarify that question. We will take out. I think it's probably about 425. 425, 31.
425.31 to what?
No, 425 to 425.
Okay, 420. 425.20.
No, 425.00.
Yes, ma'am.
To 425. I think it's about 31 or 30.
31, 32. That's what you said you're going to take out? Because that talks about the Twitter conversation. All right. Mr. Sharp, anything else from that particular time block that you wish to be omitted?
No.
All right. Any other counsel wish to be heard about anything from 425.00 to 425.33? Mr. Weinstein?
No, Your Honor.
All right. Mr. Matthews?
No, Your Honor.
Ms. T. Williams? Mr. Harvey? All right. Mr. Steele?
No, nothing further.
Okay. All right. So the state will be directed to omit that particular portion. The rest of it can be played. All right, let's move on to 6, and that would be.
This next is
Hold on, let me just frame it right quick, sir. 438.35 to 438.40, and you've indicated that. Casey saying that he has not hung out with Shannon Lodi since they shot the car. Confusing under 403 is a pronoun. They is meant to refer to people shooting at Casey, Shannon Lodi, but could be misconstrued.
right.
Okay.
So essentially, they are asking about when's the last time he hung out with Shannon and Lil D, who's Demekion Garlington. And he says, not since they shot at the car. I think any reasonable interpretation of that, based on someone who's spent hundreds, probably thousands of hours reviewing the discovery in this case, which I have and the defense counsel has, any reasonable interpretation would mean he's referring to is the people that shot at him, Shannon, and Lil D in the car on January 27th. I believe it was the day before the statement on the 28th. However, the jurors have not gone through all the discovery 10 times over as the defense has. So they have limited knowledge of everything. And when you listen to the statement in a vacuum, the reasonable interpretation is he hasn't hung out with Shannon and Lil D since they shot at the car, which makes it seem like Shannon and Little D were shooting at a car. It's confusion of the issues. It's likely to mislead the jury. And again, Your Honor, this is another one of those things I said earlier. This is not a normal trial. Yes, theoretically, first of all, there's no need to bring this confusion into this trial. So there's no prosecutorial need for this little excerpt to be played. But sure, theoretically, we could clear this up during cross-examination under normal trial circumstances. But when this is played, there's going to be several days in between that time where the jurors are likely to have in their head, if they're scrutinizing every line, oh, wait, Shannon and Lil D were shooting at a car, you know, and that's going to affect the way they look at my client. And when in fact, we can just clear that up at the time of him saying it by deleting it, as opposed to me having to come back days later and try to clarify and draw everyone's attention back to this incident and this statement. So I just think under 403, to avoid confusion of the issues, we could easily just redact this little segment and clear up any potential confusion.
Yeah, Your Honor, before I even play it, the state understands what Mr. Copeland is talking about when he says when they shot at the car. The state has no intention of alluding that the they is Mr. Garlington and Mr. Stillwell trying to shoot at Mr. Copeland. And when I read this portion, I'm going to play for the court the entirety of that section, because I think in order to understand this section in context, you have to start at 438:14, because there's already evidence, or will be before this video is played, that there was a shooting on the highway in which Mr. Copeland was involved in. And the state in no way, shape, or form intends to infer that Mr. Demekion Garlington or Mr. Stillwell was trying to shoot at Mr. Copeland. That's not even something we thought of. So we'll play the whole section so you can hear it in context.
Fine. Can I get the page references?
Yes,
please,
Your Honor. We're going to start at, it's going to be roughly page 64. And I'm starting at 438:14, so it should be around line 2 on 438, on page 64, line 2. And it will go through page 65, line 1.
All right, madam. All right, let me hear it, please.
In that fucking river with them, period. This is what is going on. These two people I be with, they're gonna be Shannon and Lil D. When I'm making with Shannon, me and Lil D together all the time. That's all. That's exactly. No, Shannon still was Mickey on guards. Yeah. Me and him together all the time. Them all two I do it. Since they shot their car, I've been in the house with my baby mama. If I ain't in the house, though, we don't got to hug it. And I don't call Quay. Quay don't can't pick that up, and we just roll around here.
So we stopped it at 438:46. So in context, he's talking about the last time since they were shot at in the car. Well, before we played this interview, we would have played the January 28th interview where he's going to talk about the fact that they were shot at in the car in January 28th. And so when you read those two in conjunction with each other, I believe the jury will understand that he's saying since they got shot at the car, I've been in the house, given the full context. And again, the state will not infer that the they is Demekion, Mr. Garlington, Mr. Stillwell shooting at Mr. Copeland.
Okay.
When I said the defense attorney's been spending a lot of time with this case, also the state has. I mean, they have a background understanding. Both sides have a background understanding that's through discovery that's deeper than what the jury has at this moment. And that this line adds nothing to the understanding of the case. But, you know, I just listened to it again. I was thinking maybe I missed something. He says there's no discussion of other people shooting at the car. They said, when's the last time you hung out with Shannon and Lil D? Not since they shot at the car. It sounds like my client shot at a car.
Well, it has to be taken in context because the jury's already heard about some purportedly shooting. Okay.
Yeah, but
I understand your concern under 403. I respectfully disagree at this point, but okay. Because I don't think it would confuse them. But anyways, anybody else wish to be heard on this issue? Mr. Weinstein? No, Your Honor. All right, Mr. Matthews? No, Your Honor. Ms. D. Williams? Mr. Harvey? Mr. Steele? Okay, all right. I'm going to admit it are allowed to be played over objection. I'll still give you a continuing objection, okay? All right. Let's turn to number 7. And number 7 is 60325 to 60605. And you,
And now, by the way, it's page 155, line 1 through 156, line 2. 155, line 1 through 156, line 24.
So
okay, Mr. Short, all right, let me frame the period. It's 60325 to 60605. It alleges Casey talking about Kel shooting and at some dice
at a gambling spot,
which
I believe under the state's theory is kind of one of the incidents that's the genesis of everything, of the disagreements between the groups. And my objection is that Kenneth Copeland is basically telling the police that Kel shot up the gambling spot, but even in his own statement, his identification of Kel, now let me be clear, he does say he was there, so it's not that he wasn't there, but from my understanding of his statement, he didn't know, no one knew who shot up the gambling spot, no one identified Kel, who's Kelvin Watts at the time, but afterwards, apparently, according to Mr. Copeland, Kelvin Watts told his girlfriend or a girl that he knew at the time, whose name's Trivia, about what had happened and apparently made some confession, according to Mr. Copeland. And then Trivia tells Kenneth Copeland. So it's double hearsay. And certainly, even if Kelvin Watts to Trivia would fall under a hearsay exception, Trivia to Kenneth Copeland would not fall under a hearsay exception. So it's hearsay, and he doesn't have a basis of knowledge, and we would object to its admission.
all right, State.
Your Honor, the information about the gambling spot has already come in based on the January 11th interview in which Kel discusses, if not January 11th, February 20th, but the 2 interviews that have already been played before the jury. Mr. Copeland has already said in both of those interviews that there was this incident at the gambling house in Lakewood, and that it was Kel who did it. And more importantly, when he met with Kel at the Cascade skating ring, maybe the next day after this gambling incident, that he talked to Kel about the shooting at the gambling house, and that it was during that meeting at the Cascade skating ring that Kel got on the phone with Mr. Williams, and Mr. Williams asked for Kel to pay for the window that was shot up at the gambling house. So one, the evidence is already before the jury about the gambling house. How we get to who told him is irrelevant, because it was the effect on the listener, meaning Mr. Copeland, that once he gathered this information, he's using this to try to squash the issues between Copeland and Kel. And so when he's relaying to Detective Gaither the beginning of the conflict between him and Copeland, he's just now reiterating how he got the information that Kel did it and what effect that had on the issues between the two of them. So who told Mr. Copeland that it was Kel is irrelevant to the sole fact that he thought it was Kel. That was kind of the beginning of their issues with each other. And as a result of knowing that it was Kel who did the shooting, Kel then in turn confronts Copeland in turn in front.
Man, you talking about the straight
Copeland
like
in
that.
turn confronts Kel
That
about
might
the
be the most
shooting.
relevant piece of information.
And during the course of his confrontation of Kel, also had a conversation between Kel and Mr. Williams about the shooting that occurred. So this portion as to how he found out it was Kel is not, while hearsay is really effect on the listener, but this is already information that's before the jury. But it's important, Your Honor, because let me say this, that defense counsel is arguing that Copeland consistently lies. What this shows is that Copeland's giving the same series of events to multiple different investigators at multiple different interviews. And so that shows that at least back in 2015, when he's recounting his history with him and Kel, he's telling different investigators these same series of events that occur leading up to the murder of Donovan Thomas. But I'll play the section for you if you want to.
All right, sir. Yes, ma'am. Go ahead.
And I'm going to start at 6:03:22.
But that what it was about. Then they got mad. The D got jumped in the club by NBC. They tell the D, we ain't got you because you be with them. They asked the D, why they ain't got you? I don't know why. It was no, but the whole time they don't care then because this is a gambling house we go hang it and gamble. We go there and gamble. We come out the league. Kel, I'm in the bush. Kel, Stewart, and they never mentioned the third person name. And Bush, they started showing me them. They shot so many times. Shit, I was glad to hear that. Huh? Okay, wow. In Lakewood. They shot so many times. They shot damn near everybody caught. But they missed everybody. They graded one person probably bad. But when police can't hear, left. Co-people left. But they don't care. But that's the same like NBC jumped on the D. So they did that make sense like NBC did. But I pulled over and going home. I stayed out about 2 or 3 years. So I was telling them like, damn, bro, y'all ain't gonna come out there. Y'all trying to kill me. What's up, bro? And they like, hell nah, bro, you tripping. Like, bro, we ain't see that y'all do with one of the NBC niggas. Like, bro, we ain't got no problem with that, bro. You didn't. Y'all don't let D be with me, bro. I'm on the stage. I was like, nah, bro, y'all tripping, bro. In my tongue, bro, nah. They keep trying to get into the state. But nah, the next thing know, Big Boo came up there, and one of them niggas on swarm. He grabbed the D out the stage, started jumping on the D. I ain't know it was a D, I'm thinking they wanted them jumping on them. So I walked out the club, see the D, him got shot in the hand, and he bleeding and shit. What's wrong with you? What happened to you, bro? And he couldn't talk. He like, and I was seeing the hammer, but damn, they shot you too. So he went down there now. He went to the hospital, so I had to tell him over what happened. And Pinky went down there with him. Goddamn, the next night we had a gambling house. They ain't not putting no pictures. We in that gambling. They take pictures and shit. Then he came out there and shot at it. We found out it was Kel. He had got into a Gucci Red. And she was hosting him. She came back and told her, like, man, it was Kel and shot at y'all mixing like they did. Because they shot at it and they went and shot at Monday spot. Monday we got into it with the NBC name. They bombed, boom. They had the fight started. They went shot at their house on Metro Pies. Shot house on through the room. Okay.
And it ends at 6:06:07.
So to put a little context to what you just heard, this gambling spot was shot up, according to Mr. Copeland. It was assumed that it was people from a group called NBC, because according to Mr. Copeland, Mr. Kendrick had gotten into some sort of dispute with someone from NBC around that time, is what Mr. Copeland's saying. I don't know if that's true or
Mr.
not.
Kendrick or Mr. Garlington?
Mr. Kendrick. I think he says Monte. I'm assuming Mr. Kendrick. Might not, maybe someone else named Monte. And I don't know if any dispute occurred. But what he's saying is it was assumed it was NBC. And then through hearsay, it came out that it was Kel. Through hearsay, through trivia. And so our stance is that's hearsay. Effect on the listener is much narrower an exception to hearsay than the state's been putting forward in this case. Throughout this case, they've been relying on effect on the listener quite a bit. I don't believe that it's quite as easy to get around the hearsay rules under just saying effect on listener. And his knowledge, he's giving a historical narrative of this event, and his knowledge of who committed the event or committed the act is based entirely on hearsay. So
What about the issue that we've heard testimony already about the gambling?
Then it's cumulative.
Then the shooting of the gambling house.
Well, if we've allowed that in the past, then that's on the defense counsel for not flagging that. But at this point, it's cumulative if it's come in already.
I believe it's already been testified to. In fact, I think Mr. Copeland earlier in his direct he's testified about that on the stand, about the shooting of the gambling house and this kind of historical perspective.
At this point, then it's cumulative, and if collectively we have missed it in the past, we're flagging it now.
Okay, all right. Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor, just adopt.
Ms. T. Williams? Mr. Harvey? Sir? Turn your mic on, sir, please.
I want to adopt what Mr. Shart said with regard to the effect on the listener. Effect on the listener is usually most often used as evidence of motive. It has not been used in that sense, and therefore it has been abused and continues to be abused as the basis for the admission of these clearly hearsay statements. So, for example, in Gates versus the state at 298 Georgia 324.
One more time, Gates.
298 Georgia.
All right.
324.
Yes, sir.
There were text messages admitted that were sent to the defendant's girlfriend, not for their truth, but for the effect on the defendant in establishing motive for a murder. That's the usual basis upon which hearsay statements are admitted for the effect on the hearer. That is not the case here. This is not the defendant. It doesn't establish motive. So I would adopt and expand Mr. Shart's reasoning.
All right, sir. Mr. Steele.
Nothing to add.
All right, sir. Excuse me. All right, folks, we're gonna take a comfort break. Let's take 5 minutes. Come back. I'll make a ruling at that point in time on 7, okay?
And Your Honor, before, the state did want to respond to what Mr. Harvey said. And so I didn't know if we could get an opportunity to do that prior to the court's ruling.
Okay. All right, recess. you said you had a response to Mr. Harvey's comment.
Yes, Your Honor, very briefly. In
Looking at Gates, Your Honor, specifically the portion which they talk about the effect on the listener. Yes, this was a murder case, but what it says, and this is in Division
2,
2.
I have it up.
Yes. And when you read the fullness of it, it says, for a statement of constitutional hearsay, it must be offered in evidence to prove the truth of the matter asserted. And it cites the statute. Here, the declaring statement at issue was, you're ever lonely, you can call me. The text message sent along with the naked pictures was not offered to prove that Gates' girlfriend could in fact call or had permission to call Wilson if she were lonely. Rather, the text messages were offered to show its effect on Gates and in this case, his motive for committing the murder. An utterance may be admitted to show the effect on its hearer. See also Miller v. State, 275 Georgia 32. For such a purpose, the statement would not be hearsay as it was not offered for the truth of the matter asserted, but for the effect or lack thereof on the hearer. As such, Gates claims that this evidence was inadmissible because it was hearsay without merit. Here, again, Your Honor, learning about the fact that Kell shot at the gambling house, what Copeland took with that information is he confronted Kell about it. They had a discussion about not just the gambling house, but all their other issues that they had with each other. And then furthermore, during this interaction, which was, I believe, the next day after the gambling house or some time later, Mr. Williams then speaks to Kell about that shooting that happened at the gambling house and specifically about paying for the window. So again, Your Honor, it's not about what, and I believe it's Gucci Red. I think Mr. Shar said that it was Trivia who said it, but I believe he said Gucci Red told us it was Kell. That information is what he used to confront Kell about what happened at the gambling house. So that's what the state wanted to add.
What's your response to the defense's assertion as well as cumulative? Because it's been testified to.
Because, Your Honor, defense counsel assertion is that Mr. Copeland lies about everything. And so what his reiteration of this incident shows is that not just in the February interview, not just in the January interview, January 11th, he talks about it, I think, briefly in January 28th and February 20th, that he's reiterating these events to different investigators to talk about the history of what has occurred between them. And if he's such a liar as they want to purport him to be, then he would not be able to recount this historical perspective to the detectives that he is meeting with. So while he is repeating the story, he's repeating it to different detectives at different times to show that he is at least consistent with the historical events that lead up to Donovan Thomas's murder.
All right. Okay. All right, counsels, I've had an opportunity to consider your arguments as well as take a look at Gates 298 Georgia at 324, as well as Garner versus the state at 342 Georgia Appeals 824. Both of them stand for the same proposition about effect on listeners. So I'm going to permit that to be the inquiry area of 603, 25 to 60. Hold on, get back, hold on. (603.25) through 606.05. All right. I'll give you a continuing objection, defense counsels, as respect to that. Let's move on to 8. I believe 8 is 6/19/20 through 6/20/20. And I believe that is Casey being reluctant to cooperate in the shooting investigation where he's a victim. He says he's concerned they will put the discovery on IGS or Instagram.
Yes.
Okay. Can you give me the page references, Mal?
Yes, Your Honor, so page 173 line 7 through page 174.
Okay, all right, Mr. Sharp.
So, Your Honor, here is another example of Mr. Copeland stressing the social ramifications of cooperating in this investigation. Again, when I say this investigation, I'm referring to an investigation against people that shot at him allegedly outside of his house while holding his child. We get into this, it's almost bolstering, it is bolstering, where he's showing a fear of testifying, but again, it has nothing to do with these gentlemen, it has nothing to do with the investigation of these gentlemen seated in court today, but it has to do with an entirely different group of individuals that are allegedly associated with an entirely different group. So it has no relevance to this case. It creates the impression that Mr. Copeland is universally opposed to cooperating, universally fearful, universally has been threatened and feels threatened. But the reality is he's expressing fear, reluctance, and all the rest regarding an investigation of an entirely different group of individuals. And it's likely to confuse the issues. It's unfair prejudice towards our clients where there's absolutely no evidence that he's been fearful, that he's been threatened by any of these gentlemen or anyone associated with these gentlemen. So we would argue that it should be excluded under 403, 401 and 403.
All right, madam, can you play it, please?
And Your Honor, I'll start at 6/19/40.
You know my name? In that car that's gonna put them there. Like you worried about the wrong thing. I'm worried about when you get locked up and you get a skirt back and see I inserted each picture and put my name on them. You're gonna send it out to the screen and be like, I done told on him. And they're gonna put it out on Instagram and Twitter and they're gonna tell everybody. And then guess what? They're gonna start like, damn, I'm gonna be just like what then? Nobody won't be around. So you worried about your reputation as opposed to your life and being a free man? It's up to you. I don't want to go back and forth. You gonna do it, Woody, or you not?
And Your Honor, that's the conclusion at 6/19/44. And we started at 6/19/06. And Your Honor, may I respond?
Yes, ma'am. What's the state's response to Mr. Chard and the defense attorney saying that violates 401 and 403?
So again, Your Honor, one, this is a impeachment by contradiction. Again, in court, Mr. Copeland has said repeatedly that they forced him to pick out Tay, and that he was not afraid of snitching or telling the police who did it, but that Tay did not do it. So one, this is a contradiction to both of those assertions that he made in court. Here, again, for the totality of the case, Mr. Copeland, back in 2015, and we believe even now, does not want to come to court to testify against whether it was Tay or these individuals. So this shows, one, he contradicted his testimony as to what he did back in 2015 as it relates to Tay. And then two, it shows not that he's fearful that anyone's going to harm him, because the state has never asserted that any of the defendants were going to harm him. What the state has asserted is that he does not want to come and testify against them. And this is a prime example of that. So for those two reasons, we believe that this portion should come in. Additionally, Your Honor, when Mr. Shar says this had nothing to do with this case, that is not true. What Mr. Copeland is talking about in this interview is a retaliatory shooting that occurred as a result of Donovan Thomas being murdered. So again, putting this all in context, Mr. Thomas was shot and killed on January 10th. Over the course of about 6 to 8 weeks, there are multiple shootings. We went over that yesterday, Your Honor. And one of the final shootings was on February 19th when these group of individuals that were associated with If Gang shot at him, his child, and his baby. And they're trying to get him to identify who one of those individuals were. So it does have something to do with this case. It has something to do with the overall retaliatory shootings that occurred as a result of Mr. Thomas being murdered. And again, in this section, he talks specific about having to come to court. Like that was his concern here. Like I have to come to court and I'm going to have to testify about this. He was concerned about doing that. And Your Honor, we believe that that is also why he's changing his testimony in court today. Court during this trial.
Any further argument, Mr. Weinstein?
No, Your Honor.
Mr. Matthews?
No, Your Honor.
Ms. D. Williams? Mr. Harvey? Mr. Steele?
Nothing.
Okay, all right. All right, in considering the both sides' arguments in regards to defense 401 being relevance, 403 being unduly prejudicial, or in the state's assertion that is impeachment by contradiction, the court does find it is relevant for the, and that even using 403 as a balancing test, it is more probative than prejudicial and shows impeachment by contradiction. So I'm going to allow it over defense objection, and I'll give you a continuing objection in regards to that. All defense counsel. All right, let's cover number 9. Number 9 is 626:30 through 627:05. And as you framed it, Gaither gives speech about the need to put an end to the shootings. All right, sir, go ahead.
I was gonna,
You want to play it?
yeah, can we just play it and then?
Yes. And Your Honor, it's page 181, lines 8 through 12. I'm going to start a little earlier at 6:26:22.
I can't deal with this shit, man. And I understand that, but you gotta help you right now. We trying to get a stop to all this back and forth shooting. You trying to back and forth shooting? Gee, they only shooting at you. Shit. We trying to get a stop to this. And we pulling every resource in the city that we can, but we can't be everywhere. So if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do, but you gotta fuck it. I'm doing what I gotta do, but help me out. I'm doing it. Hell, man. Why did I go through this, man? I don't know. I don't know, but I'm into it. Bruh, I'm ready to get started on the aftermath. I'm ready to get started on that. I can't work towards homicide. I'm picking up the pieces of the aftermath for the homicide. Here.
Your Honor, we stopped at 6:27:30.
So, Your Honor,
All right, sir.
my objection, again, these statements are allegedly prior statements. I mean, the reason we're playing for the jury over our objection, to defense objection, is because there are prior statements by Mr. Copeland. We have the non-declarant, Investigator Gaither, just talking about the need to end the shootings and how she's going to end the shootings, and the city's putting every resource into ending the shootings. And it really, you know, we're all citizens here. We're all city of Atlanta. We're all Atlantans. It's not the city versus these gentlemen. It's not supposed to be the police force in the city versus these gentlemen. And it's supposed to be a neutral. And that's the impression that the jury is given when they're exposed to, again, this speech. I call it a speech, but whatever you want to call it, by Investigator Gaither, where she presents this as, look, it's, you know, the city and all the authorities and the police department, we're all working to try to put an end to these shootings, and it's you guys and Mr. Copeland, it's your information that will put an end to it, and it's your group that's involved in all this. I believe it's inappropriate. I believe that it invites the jurors to consider it invites them to take into consideration factors that should not be considered in that jury room. And it's essentially an improper argument. If it was made during closing, we would argue that it's an improper argument. It's, you know, just because it's not a closing argument doesn't make it not improper. It's improper for the jurors to hear that type of talk by Investigator Gaither, especially considering the whole reason that this tape is being played over our objection is not for Investigator Gaither's words, but for Mr. Copeland's.
All right. Ms. Hilton.
Again, you have to look at this in totality, Your Honor. This starts off with Mr. Copeland saying, why do I have to go through this man? And Gaither is then going into, I need you to do this. I need you to identify who it is so that I can get started on my investigation. So I can continue my investigation. I can continue my work. So while Mr. Sharp calls it a speech, she's responding to Mr. Copeland saying, why do I have to go through this? And if you look at his body language, he was struggling to move forward and just make the identification. And so she's trying to encourage him to go ahead and make the identification so that she can move forward with her investigation, Your Honor. So again, as the state said earlier, that's in contradiction to what he said here in court. What he said in court, they were forcing him. No, they were talking to him about it. He's responding back to her. I believe in court, he may have said they made him say Tay. That's not true. That's what this shows as well. And so given his in-court testimony, this is contradicting what he said here in court.
All right. Any further argument, Mr. Weinstein?
No, Your
All right, Mr. Matthews,
Honor. Nothing can.
Ms. D. Williams, Mr. Harvey, Mr. Steele.
Your Honor, I don't see why this adds anything. I join everyone else, Mr. Sharp's argument. The detective said we're going to pick them off one by one. Every officer is going to be working. The state is saying that Detective Gaither is encouraging Mr. Copeland. That's not needed. That's not the purpose. We don't just play recordings of me speaking with a witness to say I was encouraging the witness. This is just an out-of-court statement offered to bolster the detective, and that's really not appropriate in my opinion. And it's irrelevant under 401(2), and then 3 would be waste of time. A lot of this, the state wants to play, these are, I believe, 18 hours of recordings. I mean, at some point, they don't get to just play all these recordings, so I would object.
And I can respond to Mr. Steele specifically. if the court may.
Yeah, I'm in, trying to kind of see why detective gave it, before it starts, we're trying to stop this, we're pulling every resource in the city. We can't be everywhere, so if I gotta pick these motherfuckers off one by one, waiting on evidence to come back, then I'm gonna do what I gotta do. But you gotta I'm doing what I gotta do. I'm doing it. I'd be inclined to take that out, but the other stuff would be admissible under impeachment by contradiction or relevant.
So which line, Your Honor?
Line 8 on page 181, line 8 through line 12.
That's fine, Your Honor.
It does, I agree with Mr. Steele. It doesn't really add anything to it, and it's for the reasons he mentioned, okay?
Okay, so line 8 to 12. we can-
Yes. Anybody else have any other comment or any other argument in regards to number 9, 62630 or thereabouts is 62730? All right, I'm gonna, other than that particular omission or exclusion from, that'd be page 181, using state's transcript, lines 8 through 12. The rest is, can be played.
Thank you.
Okay,
Yes.
all right. And I'll again, admit it over objection and give a continuing objection. Does the defendant still maintain that none of this is proper and they should not be played? So, okay, all right. Number 10. Number 10 is 63030 through 63150. And you are saying that that's 404A evidence about Mr. Stillwell
Yeah.
and inappropriate comments about character.
Yeah, 404A and B.
404A and B. Okay. All right, sir. Oh,
I'm sorry, Ms.
you want to play it first?
Yes, please.
Okay, all right, let's play it. What transcript pages, madam?
Another portion will be page 185, line 17, through page 186, line 19. And we'll start 630.
630 what?
She wasn't looking at it serious like how it is. I really wasn't. I really thought he wasn't. I didn't think they would do it. I didn't think they knew to try to shoot me. I'm afraid I thought we were going to try to do a kill. They showed me wrong. Well, I know him because he been on Twitter going back and forth with Shannon. Yeah. What the hell? I'm telling Shannon, why the hell you ugly? You on Twitter? What's Shannon been up to? Because I know he ain't just going to sit and let it ride like you get shot at and all that. I know that. And you know what I told Shannon? Let that boy deal with him. I'm man, he'll pay him. You know what Shannon told me that night? The night they shot me in bed. You know that night? I was crying. And you know that night? Man, bro, hell nah, bro. We take anything you can. I'm like, bro, fuck this shit, bro. Let them have it, bro. Let them have it, bro. They kill me, bro. You know what's going on, bro. Just started with Lieutenant Shannon. Police involved with it. They started with it, bro. We ain't going to jail, so we ain't do, bro. You're not going to tell you one of these folks think we did this shit. And that's what I told him. He like, she looked at it. She like, bro, I'm telling you, bro, if they kill you or they hurt you or they, bro, they gotta kill him too. Just like him, bro. They don't get your shell out of it, bro. We already in the battle. We with people we never thought we'd be with, bro. Bro, fuck that shit, bro. Let them have it. That's why I really ain't getting in there. If I didn't like, I feel like.
And stop at 631. So sorry, stop at 631:51.
All right, Mr. Sharp.
So this testimony or this out-of-court statement by Mr. Copeland about my client has absolutely no relation to any charged conduct in this case. It's propensity evidence. There's no evidence of something that happened that I know of. There's no evidence of something that happened after this date that was supposedly done on behalf of Mr. Copeland in as payback for either the January 28th shooting of Mr. Copeland in the car, or shooting at Mr. Copeland in the car, or the February, I guess it would be 19th shooting of Mr. Copeland, or shooting at Mr. Copeland outside of his house, other than, of course, Mr. Copeland shooting back at those individuals and hitting them in their car. My point being, Mr. Copeland is essentially saying that Shannon has encouraged him to, and said, we need to get payback for them shooting at you. And Mr. Copeland saying, no, I said, let it be, let it be, let it be. This is not testimony about any act that's charged. This is mere propensity evidence that Mr. Stillwell is someone that when something's done to him or one of his friends, he's going to seek retribution from the other side. And again, if the state had a overact, and I'm making this up, that happened on March 3rd of 2015, where they allegedly saw the car that was shooting at them on January 28th, then I would say, okay, maybe that has some relevance to this specific act. But there's no act that's charged. And what the state wants, essentially the logical conclusion based on hearing that, is Mr. Stillwell is, a hothead that seeks revenge. That's propensity evidence. That's exactly what's not supposed to come in under 404B. And so I would object. It's improper character evidence. It's improper propensity evidence.
All right, sir.
Yeah, we won't play it.
Okay. I'm gonna use Mr. Adams' favorite saying, easiest decision I'll make today. All right. Anybody else have any other comment about so part 10, 630, 30 through 631, 50? It's gonna be omitted. Anyone? All right. Okay, we've gotten through the flaggings of Mr. Sharp. Does anybody else have any other time periods they wish for me to discuss with the court? Mr. All right, thank you, Mr. Steele. Mr. Harvey? Ms. D. Williams? Mr. Matthews?
No, you're not.
Mr. Weinstein?
No problem.
Okay.
When I say
No, it's with reference to my continued objection for severance and instructions with regard to all of this evidence. I don't want that to be deemed to be a waiver on the record.
Okay, Mr. Harvey, in no way, I'll note it again for you that you have moved for severance and for 105 instruction, which the court is going to give you continuing objection on, but I'm going to deny that at this time again, okay? All right, sir. Okay. All right, councils, let's talk a little bit about way ahead in scheduling. I believe that you all have, as well as it pertains to Mr. Copeland, June the 10th interview, which is the longest one, is 9 hours. Is that correct? All right. Have you all been working on, or I'm going to ask the state first and then defense counsels in terms of what you've identified as to what you're going to play and what you wish to omit.
Your Honor, we sent to defense counsel, I believe on Monday, the areas in which the state, I'm sorry, let me stand up. The areas in which the state intends to redact. Yesterday evening, Mr. Shard, I think, sent me a portion of the areas that they would like redacted. We haven't had the opportunity to look at those. And then I believe Mr. Adams is supposed to send me the secondary portion of that. And so we'll be looking through that over the course of today and this weekend to determine what, if any, areas we can agree to. Once we finish talking about June, Your Honor, I will briefly just want to get some clarity on February 21st, but after we finish the June discussion.
What do you mean you want clarity on the
So we
21st?
submitted some redactions for February 21st. And I don't know if, kind of along the same lines of the conversation yesterday, if there are areas that the defendants wanted in that the state intended to redact. And if there are those same line of area, we understand the court's ruling from yesterday, but we just wanted clarity because we don't know. And it could be an offline conversation I can have with Mr. Shard to see
I think
what their position is.
I think I can answer this. After speaking with other attorneys involved in the defense of other individuals, I believe that there is an objection to the redactions of the timestamps identified by the state. We understand that the state, in their presentation of the case, they may choose not to present some of these excerpts when they play the tape.
Which tape we're referring to?
February 21st, 2015.
All right.
But I believe that the defense is going to seek to admit portions that the state is not going to seek to admit.
And certainly that, I mean, we can have a similar discussion that we had yesterday, or I can authorize, unless there's been a specific objection, I'm going to say you can play it during cross-examination. Like similar to what I did yesterday.
Yes.
And that's fine, Your Honor. We'll
Okay.
object at the appropriate time.
Yeah, if appropriate, yeah, I'll rule upon it. But most of the things that, unless there's clear argument to the contrary, will be fair game on cross. Okay.
Thank you, Your Honor.
Okay, so let's talk about the June 10th interview. So is it possible for you all to, like, consistent with, this has been very helpful for you all to identify the time periods and for us to work down through them and have a discussion one way or another. Are you all in a position to potentially put something together by Monday? And so we can kind of go through the June 10th interview?
The good news is we're all operating off the same transcript for June 10th, and there is a transcript. I believe the transcript's about 550 pages. I made it through 380, and I've identified the specific spots that I object to, and I believe that other attorneys involved in this case adopt my arguments for those first 380. Mr. Adams is diligently working. He's identified the rest, and he is going to send that information over to the state at some point. I don't want to speak for him, but I know he's been working on it. So I think that the state has given us their proposed redactions, correct?
Correct, Your Honor, but I think we're going to be in the same position. So we really need their redaction because I think the state is, we're going to redact what we're going to redact. And if they choose to want to play certain portions, we can object at the appropriate time. So I think we really need to know what their redactions are in order for us to have a meaningful hearing, hopefully on Monday.
So right now they have about 2/3,
Okay.
just by the transcript length, about 2/3 of the redactions, and then Mr. Adams is going to get them the rest.
Mr. Adams, will you be finished by Monday?
Oh, absolutely. They'll have them. I can give it to them on Saturday.
Okay. All right. Okay.
That works.
All right. So we'll work on, now, as it pertains to, since we'll probably take the most of the day with that, I'm inclined not to call in our juries for Monday.
And Your Honor, I'm going to remind the court that we also have the jail phone calls.
Yes, and there's 11 of those at 2.5 hours. All right, and then you counsel, as you all recall, Tuesday, the 25th, we'll probably just work from about 9:30 to about probably shortly thereafter lunch. So my inclination as well, I don't think we're going to probably finish with it's possible that even if we, that we'll spend or exhaust most of Monday the 24th and Tuesday the 25th, getting through the 10th and/or 10th of June, as well as the jail calls, and we may not even be finished with those. So I'm inclined to just tell our jurors have a nice week, unless somebody has something to the contrary.
Nothing from the state, Your Honor.
Okay, anybody? Okay, I mean, I just don't think we'll be in a position for them to hear anything at that point. All right. Which leads me to July 1, 2, and 3. More than likely, we'll probably use, if we don't finish up our business with the jail calls, we'll probably take that up on Monday, the 1st of July. Tuesday, we'll probably do the in-camera review of Mr. Copeland's ex parte matter. And I will give you all more pinpoint instructions on that particular time and date. But it more than likely will be the 2nd or the 3rd of July. So that's our kind of work schedule at this point in time, to clear those issues before we call back our jurors.
So at this time, we're thinking no jury for the week of the going to the 4th.
Probably not, is what I'm thinking. And I may tell them that so they can adjust they can govern themselves accordingly. But we have a fair amount of stuff to take care of. So, all right. Anything else, councils, at this point in time? If not, I'll see you all on Monday, the 24th, 8:30 for an anticipated 9:00 start time. We'll queue up the 10th, the June 10th, 2015 interview and see where that leads us. Okay?
Thank you, Your Honor.
All right, anybody else? Okay, all right. We're in recess until Monday, the 24th at 8:30.
All right, y'all. Well, we are in recess until Monday. Glanville making plans like he's still gonna be hanging around. We'll see what the Georgia State Supreme Court got to say about all of that. Anything pop off between now and then, I will definitely be back to let y'all know what is going on. This is I-78. I appreciate all of you guys stopping through. I will be back on later on this evening. We got to talk about our good friend Nathan Wade and his recent television interviews. So you guys definitely make sure you come back for that. And I will see you guys later.